Good afternoon, distinguished participants. My name is G.A. Lee, and I'm a Crime Prevention and Criminal Justice Officer at the Justice Section of UNODC, where I focus on non-custodial measures and restorative justice in criminal matters. It's a pleasure to speak today on the international legal and normative framework on the use of non-custodial measures. But before we go into the normative framework, I think that it's very important for us to think about why it is that we use alternatives to imprisonment and why it's important for the criminal justice system in general. And there are many reasons why non-custodial measures should be used as much as possible at all stages of the criminal justice process. First and foremost, the primary objective of non-custodial measures is to enable penal sanctions to be individualized to the needs of the offender and strike the right balance between protecting the society and the rights of the victim. And this kind of individualized sanctions makes them much more effective in terms of meeting the objectives of criminal justice systems, such as deterrence, rehabilitation of offenders, and restoration of the harm. Imprisonment, although it is the most widely used sanction, is only part of the picture in meeting these objectives. And in many cases, the imprisonment is not necessary, nor is disproportionate to the offense committed. And non-custodial measures can better meet the objectives of such criminal justice sanctions. And thirdly, using non-custodial measures alleviates prison overcrowding. In the recent decades, prison overcrowding has become a huge issue in many member states in most parts of the world. And a solid majority of countries worldwide are operating with overcrowded prisons. And at least 25 member states report that they are operating at more than 200% of their official capacity. And an even more problematic figure of that is out of the 11 million people behind bars currently, over 40% of this population is held in pretrial detention, meaning that they have not even had their day in court. This is extremely, it's a big cause for concern because imprisonment should not be the default rule when it comes to people who are accused. Another alarming dimension of this problem is the increase in the number of female prison population. Although female prison population make up less than 10% of the world's prisoners, they're increasing at a much, much faster rate than that of the male population. Since 2000, the female population has increased by 50% compared to only 18% in men. So there's obviously a disproportionate impact of some of the criminal justice policies on women. And all of these problems it's a very pressing problem faced by many member states. And using non-custodial measures is not the end all be all, but is definitely one of the measures that member states should be employing to reduce the prison population. And also non-custodial measures are also less expensive for society in general than deprivation of liberty. Deprivation of liberty, and it is a much more efficient use of resources that are already limited for many member states. So it's just a rational response to crime than relying excessively on imprisonment. It also reduces recidivism and better supports the rehabilitation and reintegration prospects of offenders. Against that background, I will now speak a little bit about the legal and normative framework on alternatives. So the use of non-custodial measures is anchored in international human rights law, in particular the International Covenant on Civil and Political Rights, which, as you know, is legally binding to states parties. And in particular, Article 9 provides that it shall not be the general rule that persons awaiting trial shall be detained in custody. And this is, as it is a legally binding treaty, this is a legal obligation that is imposed on all member states who have ratified the treaty. And this pretty much provides that detention should not be the general rule, and it should be used as a last resort, and other measures such as non-custodial measures should be preferred when an offender comes into contact with the criminal justice system. And this international obligation is elaborated by the United Nations Standards and Norms in Crime Prevention and Criminal Justice. This refers to a body of standards that have been adopted unanimously by member states over a period of more than 60 years in various aspects of criminal justice. And in the area of non-custodial measures, the most relevant standards are the United Nations Standard Minimum Rules on Non-Custodial Measures, or also called the Tokyo Rules, which was adopted in 1990 and provides guidance on the types of alternatives available, on its implementation, and also provides for legal safeguards so that it is implemented in a way that does not infringe on the offender's rights. And complementing that, the Tokyo Rules, came the Bangkok Rules in 2010, which adopts a gender perspective and elaborates on the treatment and also on the implementation of non-custodial measures on women offenders. So it actually complements Tokyo Rules and the Nelson Mandela Rules in that regard. And this was very important in that it added a gender perspective, and it also it's one of the ways that can solve the imprisonment, the increase in the women offenders that I had mentioned earlier, which is a growing problem in a lot of parts of the world. So you have to consider the gender aspects of criminal justice policy, which may at face seem fair and applied equally, but in practice it is not. And that's why we need rules like the Bangkok Rules to make sure that the ground is leveled and all the policies are applied in an equal way. So these are some of the provisions that are important to keep in mind: that pretrial detention shall be the last resort, and also that the criminal justice system should provide a wide range of measures at all stages of the criminal justice system, process. So it's not just that in pretrial stage that alternatives to imprisonment are important. In fact, it can be applied at all stages, even in post-sentencing, and it is important to keep that in mind when we talk about non-custodial measures. And these, the Tokyo Rules and the Bangkok Rules are also complemented by other relevant standards that come into play in specific contexts. These are some of the standards that are relevant in different aspects of criminal justice when it comes to children in conflict with the law, for example, or in the context of gender-based violence. And whenever these cases are at hand, these provisions should be read in conjunction with the Tokyo Rules and the Bangkok Rules. So under that overall framework, I'd just like to point out the two overarching principles in using non-custodial measures, one being the principle of non-discrimination. So the Tokyo Rules and the Bangkok Rules, just like any other legal instrument that operates under the human rights law, international human rights law, it shall be applied without any discrimination on the grounds of race, color, sex, age, language, religion, political, or any other dimensions that differentiate the different types of populations. And this is to ensure that anyone can enjoy equal access to non-custodial measures and also its application of it. But it's important to remember here that not all differences in treatment is discriminatory. Differentiation based on reasonable and objective criteria does not amount to discrimination. And non-custodial measures should be applied based on an individualized assessments, like I mentioned earlier, with specific measures to avoid discrimination that is as a result of such policies to particular groups, such as children, women, the elderly, or people with physical or mental health illnesses. And this includes people with drug use disorders, which will be discussed tomorrow by my colleague's friend. And the principle of proportionality is also at the heart of non-custodial measures. They must always be proportional to the nature and gravity of the offense committed, and should only be used in accordance with the principle of minimum intervention. And excessive measures must be avoided, meaning they must be proportionate to the offense. So those are the legal principles that apply to non-custodial measures in all cases. And also embedded in the Tokyo Rules and the Bangkok Rules are several legal safeguards that are there to ensure that the offender's rights are protected. And they can be grouped into largely 5 categories. Principle of legality, meaning anything, the introduction, definition, and application of non-custodial measures should be prescribed in law. So they should be already available in law before they can be applied. And this is pretty much it's the basics of human rights law, where, and then and for non-custodial measures in particular, the authorities that are responsible for implementation must also be specified in law. And if it's ever delegated to a third party, that should also be founded in law. And second, the criteria and the need for discretion. So the criteria, whenever non-custodial measures are applied, they should always be based on an established criteria. And in this, for non-custodial measures, it's very important that it's proportionate to the nature and gravity of the offense, personality and background of the offender, and the purposes of sentencing, and the rights of victims. So the selection of non-custodial measures out of a whole range of possibility, it should be considering those criteria in mind before they can be imposed, so that they're truly individualized. I will, in the interest of time, I will move on to the third one, where the consent of the offender is obligatory. When it comes to non-custodial measures, the offender must have consented to it being imposed on him. And this is especially important in pretrial, when they're simply accused and they haven't been convicted yet. So he or she should be fully informed of the consequences of consent or refusing to consent. And fourthly, for the right to review and the right to appeal and the right to complain about certain non-custodial measures is incredibly important. So just because something, a measure is imposed on an offender does not mean that it's the end all be all. Like, it has to be implemented in a proper way so that anything unfair or arbitrary can be reviewed by a competent judicial body. And lastly, the Tokyo Rules provide for restrictions on the imposition of various measures, including prohibition against medical and psychological experimentation, and also the offender's right not to be restricted any further than the original decision would have been. So any non-custodial measure imposed should not be worse than the actual conviction. And lastly, the offender's right to privacy and dignity should always be protected. This includes when someone is subjected to electronic monitoring, for example, it should not be excessive, and it should not be without his or her knowledge. So these are some of the priorities that we have whenever we are providing technical assistance to member states in imposing non-custodial measures, in implementing non-custodial measures. And without any, out of the 5, we find them all equally important. And we, for non-custodial measures to be implemented well, all of these pillars are key to having it run successfully. And these are some of the examples of what we are working on and where we are assisting in terms of technical assistance. I'd be happy to answer more questions about that if there are any. These are some of the UNODC tools that I hope that can be helpful in various dimensions. We have one on specifically for drug use disorders, specifically for women offenders in a gender responsive way, and also on a specific type of non-custodial measures, which on restorative justice programs. So these are some of the technical guidance materials that we have available. And thank you very much for your attention. And if there are any questions, I'd be happy to answer them in the Q&A session or by email. Any way that I'd be helpful would be good. Thank you very much for the time and for your attention.